Perfect. Good evening, everyone. Thank you so much for attending the Practice Match webinar with Elissa Taub 2025 Immigration Update. My name is Rainey McNeely. I'm a physician engagement specialist here at Practice Match. I've officially been on the Career Fairs team for a year tomorrow. So if you've attended any of our live career fairs, if you've gotten any gift cards or have submitted your CV for review, that all comes from me. A little bit about Practice Match is we offer free career resources for residents and fellows and physicians during and after your training. We have things like this webinar, our virtual and live career fairs. We also have free CV review, all kinds of free career resources to offer you. Um, I do want to remind everyone during our webinar tonight that your mics are muted and your cameras will be off. So if you have any questions, please put them in the Q&A chat box, and Elisa will get them answered during this presentation. We have some good attendance, so if you're ready, Elisa, go ahead.
Great. Thanks so much, Rainey. I'm excited to be here with all of you tonight. I'm going to go ahead and share my screen so that, let's see where it is. Sorry, I'm just looking for where there we go. So we're going to go ahead and get this all set up. Tonight we are going to cover a bunch of updates in the immigration world. Some of these updates are not necessarily physician specific, but they are really important and do affect physicians who are needing immigration support. And so I want to make sure that we cover, the news, basically, things that are going on that are really important right now. As Rainey said, I am happy to take questions in the Q&A box, and I will do my best to monitor those as we go. And now I'm trying to figure out where that box went on my screen, but we will deal with that. Go ahead and ask your questions, and if I see them during the presentation, I will go ahead and answer them. Otherwise, I will definitely get to them at the end. A little bit about me. I am an immigration attorney and partner with the law firm Siskind. I am the co-author of the Physician Immigration Handbook, and I regularly present webinars with Practice Match on immigration matters. Every time we do them, it's a little bit of a different topic. So sometimes we'll talk just about J-1 waivers. Sometimes we'll talk about green cards. We try to mix it up a little bit. So I'm glad to be here with you tonight. So with that, why don't we dive into the topics and kind of get started. So I've kind of divided these topics into things you've seen in the news and things you haven't maybe seen in the news. And of course, the first thing that anybody thinks about, even if somebody's not in the United States on a visa, even if they have nothing to do with immigration, the first thing I hear from people all the time is, oh my goodness, what's going on in the news, right? Like all of these reports, all of these stories that journalists are putting out that are pretty scary about, people with green cards being stopped at the border, people with the H-1Bs being stopped at the border, people in lawful status getting detained, all of these things. And I mention this for a few reasons. The first thing is to remember that a lot of times these reports do not have all of the relevant facts in them. And when we immigration lawyers go back and maybe talk with our colleagues who oftentimes are representing folks that are in this predicament, or we start to kind of figure out what the facts are, we realize that it's not as scary as we maybe thought it was, that there are reasons why some of these things happen, and we may not agree with those reasons. We may think that those reasons are not proper, but that there is some kind of reason that the government is pointing to, and that these issues, these things that are cropping up aren't necessarily random. And one of the challenges is that immigration is very complex, and a lot of times the journalists who are covering the story, they don't cover immigration as their normal beat. There are some wonderful immigration beat reporters at the New York Times and other outlets, but in Bloomberg and other places. But like they don't always, the other reporters don't always know what's going on immigration wise, and they may be asked to cover a story because it's like hitting the news right then, and the editor just like assigns a reporter to the story, and they don't have all the context, and they don't have the contacts with immigration attorneys to talk to us to find out what the deal is. So just keep that in mind. Sometimes these reports are really devoid of facts, and it really takes some time to peel back all the layers to find out what's going on. I do recommend there, are so many rumors out there. There's so much happening all the time. And I know, like with my clients, they all try to stay up on the news, which is really important. And then they'll email me with questions. I do think it's important if you don't have an immigration lawyer yet, because maybe you're not going through this process, to make sure that you're maybe following people online who are reputable and reliable and sharing good information. Sometimes those people can be a really good resource, not necessarily because they're going to answer a million questions for you, but because they're sharing information that's reliable. LinkedIn, I find to be one of the greatest platforms for getting immigration information directly from immigration attorneys without all the fanfare of TikTok and without all the like noise that happens on other social media platforms like X or Blue Sky or Threads. Because LinkedIn is really more of a professional medium, I find that that's really one of the places where I will go to share more interesting immigration news, and I have a lot of space to write as opposed to in other places. So wherever it is that you're consuming your immigration news, my biggest thing is make sure it's some place and someone who's reliable, and not engaging in scare tactics and and that kind of thing. So that's my first just admonition on the reporting about immigration. But in terms of substance, I want to talk about the two things that are probably first, top of mind for every single person who's on this webinar tonight, and that is the $100,000 H-1B fee and the government shutdown. So let's talk about the $100,000 fee first. And I'm going to go, I have it on the next slide, we're going to go into more detail on it, but just to kind of set the stage for those of you who may not have heard about it or who may be confused about what it is. On September 19th of this year, it was a Friday, I remember it well, at about 6 p.m. Central Time, the text of a presidential proclamation was made public that the president had signed that same day that essentially announced that there would be a ban on entry, it said, of anybody in H-1B status coming into the United States unless a fee of $100,000 was paid to get that person into the United States. Immediately, this sent shockwaves, right, through everybody who's in H-1B status now. We had clients who were traveling outside the United States. We didn't know this was coming. There was absolutely no warning. A few hours before it was signed, we started hearing some reports, some rumors, but we didn't know really what it was going to be. So people were doing their usual travel. And we were worried they were going to be stuck. So from like Friday night until sometime in the afternoon on Saturday, it was just chaos and pandemonium. A little while later, sometime on that Saturday or Sunday, the government came out and said, "What are you talking about? Why are you so nervous about this? This only applies to H-1Bs filed after September 21st, 2025. But that still left a whole bunch of questions, and those questions were largely answered this week. So on the next slide, we're going to talk about what those, how those questions were answered and the parameters of the fee. A couple of other things, though, that were included in that proclamation, or actually one other thing, was a directive to the U.S. Department of Labor to revise the rules regarding prevailing wages. And this is important because when a person is sponsored for an H-1B or for a green card, the employer has to attest that they're going to pay that person at least the prevailing wage. And that's the average wage that a person in that field, that occupation, is earning in that geographic area where the job is going to be. And last time around, in the last Trump administration, they tried to implement a new prevailing wage fee that significantly raised all of the prevailing wages across the board. The administration was sued, a judge threw it out, and the rule was rescinded, and then the Trump administration ended. And so that rule never really, it created havoc for a little while, but it went away. they're trying to do the same thing again by trying to make the prevailing wages higher. Now, the Department of Labor is closed for the government shutdown. We'll talk about that in a few minutes. So this rule has not come out yet. We've not read any text. There's not been a draft, nothing like that. So it's not imminent. But we do believe in 2026, we're going to see kind of the second round of trying to raise prevailing wages. And the idea is that it's based on this myth that, international workers in our country are being paid less than American workers. And so they're trying to almost make international workers be paid more and significantly more than American workers in order for employers to be able to hire. So that was also a part of the presidential proclamation, just this order to the Department of Labor to do this. It hasn't happened yet, but it's important to know that that's on the horizon. We'll also talk in a couple of minutes about the government shutdown and exactly what's going on with that. But let's dive more into the $100,000 fee. So as I mentioned, on Tuesday of this week, USCIS updated its website, and specifically it's the website about H-1B status. They updated that to provide more clarification and information about the fee. Up from September 19th until Tuesday of this week, we really had very little information from the government. And what information we did had was inconsistent and imprecise. And so it was very hard to advise folks on exactly what was going to happen with an H-1B petition that we were planning to file. Now we have that clarity. So the first thing to know is that this fee only applies to petitions filed after September 21st, 2025. And that day was a Sunday. So we're really talking about mostly petitions filed on Monday, September 22nd and after. If somebody is already in H-1B status as of that date, or if their petition was filed before that date, the fee does not apply at all to that petition or that H-1B. So anybody who's already in H-1B status, not a problem. Then they say, okay, well, it's not all petitions filed after September 21st. If the entire application is handled within the United States while the person is in the United States, the fee doesn't apply. So what does that mean? Extensions of stay. If I'm filing an H-1B extension after September 21st and the person is in the US when I file, stays in the US while that petition is pending, then that petition should not be subject to the fee. H-1B amendments, you're changing a location, we're changing a wage, something like that, not subject to the fee. Changes of employer handled entirely within the United States, not subject to the fee. Changes in status, like from J1 to H-1B, F1 to H-1B, H4 to H-1B, any change in status to H-1B, not covered by the fee. But the critical part of that is that the entire petition is filed and approved while the beneficiary is in the United States and USCIS approves the application, giving the benefit that was requested. In other words, they approved the extension, the amendment, the change of status, the change of employer without making the person travel abroad to process a visa stamp. And that's really critical. It's really important to maintain your immigration status in the United States by doing all of the things you were supposed to do, working where you're supposed to work, for the employer you're supposed to be working for, not working without authorization. If your job ends, not staying in the United States, longer than you're supposed to, all of these kinds of things, maintaining your status, not having any dust-ups with law enforcement, which also right now seems to be triggering USCIS to ask questions about whether somebody should be allowed to change status or process a petition from inside the US. So that is the critical issue. If somebody is abroad when their H-1B is filed, if they travel abroad while the H-1B is pending, such that they kind of disrupt the processing, or if USCIS makes a decision that the person needs to consular process a visa instead of changing, having the petition adjudicated here, that will trigger the fee. So that is, very important to understand. Just because you're here and your employer files an extension for you, if everything works out well, great, no fee, right? But if there's some problem with the filing and the government says, no, you're not eligible for a change of status inside the US or whatever it is, that's going to trigger the fee. I'm just trying to say this in different ways to make it very clear. Most cases for people who are already in the US are fine and are not going to be affected. The Immigration Service also confirmed that if a petition is approved, filed and approved while the person's here in the US so that the fee isn't triggered, that person can then travel. And should be able to process a visa stamp, should be able to re-enter the US without triggering the fee. So if the fee is not triggered, it's not triggered for all purposes on that petition, if that makes sense. If somebody's outside the US, the fee is due. So what happens? An employer who wants to file an H-1B petition for somebody where the fee is going to be implicated needs to pay the fee online with there's a special link with pay.gov where the employer can go on to pay the $100,000 fee before the H-1B petition is submitted to USCIS. And they will need to use the receipt, the confirmation from pay.gov to show that the fee was paid. Let's say, and then they also said in the proclamation and in USCIS's guidance that there is a way to apply for an exemption from the fee. In the proclamation itself, it says that the exemptions can be granted for individuals, for whole occupations, or whole employers. But in the guidance that came out from USCIS on Tuesday, they are only considering right now exemptions on an individual by individual basis. The exemption request has to be filed with USCIS via email. They created a special email box for these exemption requests, and the exemption has to be granted before the application can be submitted. So in other words, you either need to show that the fee was paid before the petition is submitted, or you have to show that the exemption was granted before that petition can be submitted to USCIS. We do not know how long it's going to take to get decisions on these exemptions. And I'm going to go over with you in a second, and you can see it on the slide, what USCIS said about the exemption and who's eligible, but this is all they've said. I'll explain what I mean by that in a second. So the exemption is potentially available to somebody where we can prove that the employee's presence in the United States is in the U.S. national interest, that there is no U.S. worker available for the position, and U.S. workers typically mean green card holders and citizens, that the employee does not pose a threat to the United States. And they said it in a weird way, but basically no harm to the U.S. And also we have to show that requiring the employer to pay this fee would undermine the U.S. national interest. And that's a quote, you undermine the U.S. national interest. What they didn't say to us is what documents they expect to see to prove each of these four elements of the exemption. But in thinking about it, examples of things that I think we need to provide. For physicians, obviously, there's a nationwide shortage. There's a lot of documentation out there about the nationwide shortage. That's important to provide. I also think it's important to provide justification for the physician coming to the specific facility and specific location where they're headed, and how that also implicates the national interest. Showing that there's no U.S. worker for the position, that's what we have to prove when we file a perm labor certification for someone when we're preparing a green card application. And there's a very detailed process of advertising the position and seeing if anybody applies for it. Now, I don't think we necessarily have to follow the perm rules here. That's not what they said. But I do think that we're going to need to provide evidence of what the employer did to recruit someone for the position, and that there were not viable American candidates available for the position. And so that can take a lot of forms, but I think and if the employer didn't advertise widely or didn't recruit widely for the position, I think they may need to do that before submitting for the exemption to show that they actually tested the labor market and couldn't find someone. But there may be other ways to do that. And that's something that we're kind of discussing behind the scenes, is like exactly what we would provide as evidence that no U.S. workers available. Showing that the employee poses no threat to the U.S. I think the first thing I thought of on that was, well, we're going to need to get background checks on every single person that we submit this for so that we can show that they don't have a criminal history. But I think it may even go further than that, and we may even need to obtain affirmative letters of support from people in your community, people that you work with, who will attest to your good moral character and that they don't know you to be someone who harbors resentment toward the United States and all, like, I think we're going to need some uh, character testimony from people about you. And then the other thing is, showing that requiring payment by the employer would undermine the U.S. national interest. That is a really high standard. And so I have to think a little bit more about, for rural hospitals and nonprofit or public hospitals that are really struggling, yes, I think we can make an argument there that it's in the U.S. national interest for them not to have to pay the fee, because we need our rural and underserved hospitals to continue operating, and not have this fee threaten their bottom line. But, okay, well, that might take the form of a letter from the hospital CEO. That's great, but the government might also see that as very self-serving. So we may need to have letters of support from politicians, both at the state and federal level, and and maybe other folks who can attest to how important the facility is to the area. So you can see these are not exemptions where we're going to be able to just draw up a quick argument and send it off by email to the Immigration Service. These are going to have to be very well documented exemption requests that get submitted. And we don't know how long USCIS is going to take to read them. We don't know how many people, how many officers they're assigning to this project. So there are a lot of unknowns about what it's going to look like, as this gets underway. I do have a couple of employers right now who really would like us to file exemption requests. And so we're starting to kind of, as I mentioned, we're kind of figuring out what this is going to look like. But we think that the standard's going to be high. And it sounds like the government, they said that they would only grant exemptions in extraordinarily rare circumstances. Previously, there was some discussion. I know there's been a tremendous lobbying effort by the medical community at the White House level to try to get an exemption for all physicians. I know, there are hospitals that sponsor residents for H-1Bs who come directly from abroad on those H-1Bs, and those residency programs cannot afford an extra $100,000 per resident. And so I know that, there are like so many different ways that this fee is going to be detrimental to healthcare in the United States. I know that there are lobbying efforts underway with that. USCIS, in issuing this guidance on Tuesday, certainly could have said in that guidance that certain occupations or fields would be exempted from the fee, and they didn't do that. Now, that doesn't mean they won't do that in the future, and it doesn't mean that those talks and those lobbying efforts have stopped. But so far, there is no blanket exemption for any particular occupation or any particular employer of which I'm aware. So I know there have been media reports about exemptions for physicians, but that's all those are. They are media reports about the fact that people are asking for this, but it has not actually happened yet. Hopefully it still will. I hold out, some hope for that, but I don't have a ton of optimism. So we'll see where all of that goes. So that is the giant nutshell on the $100,000 fee. And I will just say it one more time because I just think it's so important. If you are in the United States in J1 status right now and you are looking for jobs, and you have employers who are like, well, we don't know if we can do this because of the $100,000 fee, you can tell them, I know that the fee will not apply to my H-1B as long as I'm in the United States when we file and when it's approved, and I'm eligible for that change of status. We can go ahead. The word is getting out to employers. I've actually this week got a couple more signed contracts in, which I was like, thank goodness, because some folks had really slowed down recruitment. But don't be discouraged about that. Employers are learning about this all at the same time that we all are, right? There's no crystal ball, there's no advanced warning that any of us have on what's coming. So, it may take a little bit longer for some of this stuff to trickle out, but definitely reconnect with employers that you might have been connecting with, and see if they've kind of updated their recruitment plans in light of these updates that just came out on Tuesday, which I guess today's Wednesday. Yesterday was Tuesday. Every day feels like 100 days. So, so that's the fee. So let's talk about some more good news. And that's on the government shutdown. So a little bit of background. The federal government works on a fiscal year that begins every year on October 1st. And that's why, in immigration, October 1st is a really key day, because that's like October 1st, 2025 was really the first day of 2026 for the United States government, and for all of its operations. So on what's supposed to happen is that Congress is supposed to pass a budget and the president is supposed to sign it in advance of October 1st so that the government can remain operating. That didn't happen. It still hasn't happened. So at midnight on October 1st, the government essentially shut down. Now, there are some essential functions and certain functions of the government that are ongoing. So you can kind of see in my little graphic here, USCIS is a completely fee-funded agency. Every time we file a petition or an application with USCIS, they charge a fee. That means that they can remain operating even during a shutdown. Their appropriations, their funding that comes from Congress is a very small portion of the funding that they get. So USCIS is largely operating without any change. I know in the first days of the shutdown, the director of USCIS, Director Edlow, tweeted some nonsense about how they were going to slow everything down and not do their jobs and blah, blah, blah. I have not seen that happen. In fact, in the last couple of days, I've had multiple H-1Bs approved, other petitions received and approved. So USCIS is operating as usual. I've had clients go for citizenship interviews, green card have been approved, like the full gamut of USCIS operations are ongoing. So don't worry about that. So far, we are good. The Department of State, that's that DOS there in yellow, their consular operations are open. That means that if you have an appointment to go apply for a visa stamp, that appointment is still going to happen. They have administrative staff that has been, I think, intermittently furloughed. So we just had a client whose his visa was approved, but it took a little bit of extra time for it to be printed. And I said, look, I'm not worried about this. It could be just like the people in the office that do the printing may only be working every other day, right? And so it's just taking them longer to do that. The waiver review division of the State Department that handles J-1 waivers, it looks like they're still operating. The visa bulletin is still coming out monthly. Passports, U.S. passports are still being issued. So certain essential functions of the State Department are still ongoing and operational, which is really good news. Where the really bad news is with the Department of Labor, and that's that DOL you see down there in red. The minute that the government shut down, so did the Department of Labor. And early in the morning on October 1st, they had some employee go into their office in Chicago and turn off the FLAG website that we use. The FLAG website from the Department of Labor is really critical to H-1B processing and green card processing. With that website down, we cannot look up prevailing wages on the official government site. We cannot file or retrieve any LCAs, which is a part of the H-1B process, or prevailing wages or perm applications that are part of the green card process. We also cannot, we can't look anything up on the site. We can't even draft anything. I mean, literally, the site is just down. If you Google it, it's just gone. Like, there's a nasty note on there about the shutdown. This is a problem right now because we can file H-1Bs that were already, in process before the shutdown where we had certified LCAs, but I can't file any new ones because I can't file an LCA now. And while the Immigration Service has said that they'll forgive late filings that were caused by this shutdown, and because we can't file LCAs, if I file late for somebody who needs an extension, the problem is that they don't have any proof of status in the meantime and they can't work. So we are all, every immigration lawyer I know Oh, we've all been in deep discussion about the options of what to do if somebody's, running out of time in H-1B status and we can't file a petition. There is an option to try to change to visitor status. There are consequences of potentially trying to do that. If you leave the country, one of our big concerns is now that filing an H-1B to get you back here is going to trigger the fee. So that's a big problem. There may be other status options that we can consider. So if you are in that predicament, I strongly recommend that you consult with your immigration attorney about what the options are, because this is still an issue and a discussion that is in flux amongst immigration attorneys. Every listserv, every chat group, like everything I'm in, we're all talking, what do I do? So there's not a one size fits all answer. On the green card side of things, it's kind of the same thing. We cannot retrieve prevailing wages or perms. Nothing's being adjudicated. They are not handling any work on the back end. So if you're waiting on your perm to be approved and it looked like from the processing times prior to the shutdown that it was close to being approved, nothing is going to happen until the government reopens, and then it's probably going to take a little time for all of that to come back online and get moving again. So that these are some of the consequences of this shutdown that we're seeing. And I can't tell you when it's going to reopen. Nobody knows, what that time frame is going to look like. I think we're already at the second longest shutdown in history. So, we'll see what happens from there. So, that covers like the really, really hot topic, like happening right now, news alerts. Let's talk about some stuff that maybe you aren't familiar about or don't know about, and then we'll kind of look at some questions. So um, here are some less public developments. So I don't think I have any, no special slides for each one of these issues. We'll try to go through them a little bit quickly. The first thing, and this is very important, is that there have been changes to the procedures for immigrant and non-immigrant visa interviews. And if you follow some of this online, you may have seen immigration lawyers talk about this. You may have seen stories or blog posts about it. But this is really impactful. So going back even before COVID, there was always an option to apply for a visa in a country other than where you're from, other than your country of citizenship or residence, if there was a good reason. You could think about a million reasons why somebody wouldn't want to go back to their home country to apply for a non-immigrant visa like an H, or even an immigrant visa if they're applying for a green card from abroad. And so if you could make a good case and show that there was a reason for you to go to that country, then you could do that. And even in some cases, you didn't need a good reason. You could just go there, and each embassy might have its own policies about handling cases for what are called third country nationals, like people from other countries. During COVID, the State Department got really flexible with this because there were so many consular posts around the world that had to keep closing for COVID reasons, and they were understaffed. They didn't have enough people working. And so the State Department said, you know what, we're going to just give the utmost leniency. You can apply for a visa anywhere that you can get in, be admitted into that country and get an appointment. And that was certainly true on the non-immigrant side. And even on the immigrant visa side, if you had a good reason and that post had availability, they might agree to accommodate you for your green card application. So lots of flexibility. People were popping up to Canada, popping down to Mexico for visas. They were going to the Bahamas. They were, like all over the place. People were going for visa interviews. And so we were seeing like not as much wait time in certain places for to get visa appointments, to get the visas, get your passport back after your appointment, because you could go anywhere. And at the same time, during COVID, the State Department also made a very broad policy of allowing people to apply for their visa without going for an in-person interview, largely if they had previously had a visa in the last few years in any category, that they felt like, okay, you were already vetted, we already saw you in person, submit your documents, we'll do the background checks, we'll issue the visa. And if we think there's a problem, we'll call you in for an interview. That was kind of like how things were working. So lots of people would go through the Dropbox process. They didn't even need an interview. And it was working out really well. All of that is done. The Dropbox, the interview waiver, applying wherever you want, it is all done. Starting, if last month, basically, if you are going to apply for a visa, you need to only apply in your home country and you need to go for an in-person interview. And it is very important to know that if you look online at the State Department's newsroom and it says in their announcement, that third country nationals may be accommodated for good reason and, but that may lead to, a more difficult time getting your visa. I'm here to tell you that right now, even though it is the official policy of the State Department that if you can schedule a third country national appointment, that you should be able to still have your visa application adjudicated fairly. I'm here to tell you that most of those folks, or a lot of them, are getting denied, and they're being denied because they didn't apply in their home country. So unless there's some really good reason to try to apply in a third country, really at this point, the only option is to apply for your visa stamp in your home country, regardless of the circumstances. Now, there are some places where the United States does not have a diplomatic presence or is not engaged in routine visa processing. For those places, there are alternate posts listed on the State Department website. I know for like non-immigrant visas for Ukrainians, the alternate posts are Warsaw and Krakow. I think for Haitians, the alternate post is Nassau in the Bahamas, although that's controversial. And I'm not remembering some of the other ones off the top of my head, but there are alternate posts listed. So obviously, if there's not a U.S. embassy or an operating U.S. embassy in your home country, there may be an alternate approved post for you to go to. So it's really important to understand those changes. The other thing, and I'll just mention this and it's not on the slide, but the State Department also said that they are going to be more aggressive about revoking visas for folks for anything that they deem to be, anti-American, anti-patriotic, sentiments and things like that. So even traveling, if you have a valid visa stamped in your passport, it's really important to be aware. Make sure that the email address that you use on your visa application is one that you check frequently, because if the State Department does revoke your visa, they're going to email that email address. So you want to make sure it's not a dummy address that you're using to apply for the visa. You want to make sure it's something that you check regularly. That way you're aware of any communications that come to you from the State Department as you travel. I will say I'm not aware on a widespread basis of visa revocations. I am aware of some, but this is not something that's routinely happening across the board to a large subset of people, as far as I can tell. Okay, so naturalization. There have been a couple of really important changes to the citizenship process, and I'm not going to spend a lot of time on this, but it's important to know that back in August, the Immigration Service announced changes to the requirements regarding good moral character. Previously, I would consult with folks and tell them, look, to become a U.S. citizen, you have to have good moral character, but it's not something that we have to really prove. You just can't, they're really looking for the absence of good moral character, and they're going to look at, potential criminal history and things like that. Now they actually want you to affirmatively prove that you are a good person. They're going to look at things like your degrees and your job and have you been paying your U.S. taxes? And they may even want to see like testimonial letters from friends, relatives, or coworkers or people like that saying you're a good person, and things like that. So there is a little bit bigger of a good moral character component to the citizenship process now. And at the same time, they've changed the citizenship test. So anybody who applies for citizenship after October 20th, just this past Monday, will have to take the new test when they go for their citizenship interview. The Trump administration first time around tried to change the test back then. They were sued. They lost. That got thrown out. They've now come back at it again. And there are some answers on the test that really aren't quite right. But that's where we are. The question pool is much larger than it was previously, and you get asked more questions and have to pass by answering more questions correctly. Anybody who applied for citizenship before October 20th, even if they're getting interviewed now, they take the old test. So I have a lot of clients that are in that situation right now. So those are the changes to the citizenship requirements. Again, something to really, if you're in the process of applying or you're thinking about applying, definitely something to consult with an attorney about because it has changed. And the interviews are getting to be a little bit weird sometimes. So it's a good idea to have counsel for those things. Underserved area updates. For those of you on J's, it's very important to know that at the end of September, around the 21st, 22nd of September, the federal government completed its periodic review of all underserved areas in the United States. And there are now many locations that may have carried designation for a lot of years that are now proposed for withdrawal. That means that for some reason, when the government did its calculations, something didn't add up right this time. It's a large number. In fact, I met with somebody today who said, oh, well, we know our local hospital is underserved and has been for many years. And we went on and we looked and it's been proposed for withdrawal. So it's a good idea. We've been double checking a lot of our clients' sites to see what's going on. Some J1 waiver programs will not support waivers if the location is proposed for withdrawal, even though that location is designated until it's actually withdrawn. Because we think the withdrawals are going to happen in July, right after you all might finish residency or fellowship, there's a concern at the program level that if they grant the waiver, by the time the physician is going to work in that job, the area is no longer going to be underserved and qualifying for that waiver. So this is something that's happening right now. We're still discovering all the times different areas that are proposed for withdrawal. Some programs are still doing them. They're like, come on, as long as it's still designated, like we'll do them, get them in, get them out, right? Like, so it's really a program by program thing. I can tell you HHS will absolutely not support waivers in locations that are proposed for withdrawal. That has been a longstanding policy of theirs for a few years now. Other programs, it's really a program by program consideration. So if your lawyer if you're in the process of going through a J1 waiver and nobody has contacted you that there's a problem, the likelihood is it's fine. But for employers or for those of you who are, still looking for jobs and everything, I think it's a good idea to make sure that, it's been double checked. And I told folks I spoke with today, like I just double checked the location. We're all good. And in fact, in one of my clients' cases, their score went up. So that was even more helpful. So just a little info there. And then the final thing I'm going to cover tonight, and then we'll open up for questions, is changes to the USCIS payment system. And this is something that most of you are never going to see, but it's important to know what's going to happen next week. Starting on Monday or Tuesday, the USCIS is no longer going to take fee payments by check. That's how we've always paid fees with USCIS. We've cut a check from our firm's account, like our client pays us the government filing fees, we cut a check to the government. Starting next week, no more checks. You can only pay by credit card or ACH withdrawal from your bank account. And this has led to, for law firms, like we have had to go through a whole system to change the way we pay government filing fees. And I'm not going to get into the details of what we're doing, that we and our colleagues around the country, like how we're processing this. But I will tell you that I told my team that we really want to avoid filing petitions on Monday, Tuesday, and Wednesday of next week because I anticipate that the USCIS lockbox mailroom folks are going to be sending a lot of petitions back improperly regarding fee payment. And I don't like my clients to be wrapped up in that kind of chaos. I typically, when I think there's going to be chaos, I just don't file. Everybody else who files, they can go ahead and sort out all the details while everything is a mess. And when all the details get sorted out, then I file my cases. So, because when USCIS rejects a case in the mailroom, it can take 7 to 10 days to come back to us. I would rather maybe like 3 or 4 days, let the dust settle, and then file my cases. So, next week, there's going to be a lot of upheaval, I think. in filings with USCIS. So just be aware, if your immigration attorney tells you next week, like, hey, we're going to wait a couple of days, or if they're trying to rush something out this week for filing, which I am doing, there's a good reason for that. And, we're all just trying to be really careful about how this process is going to work, and it's going to be a lot messy. So that is my last topic. And here's my contact information. In a second, I'm going to stop sharing my screen. I do mostly phone call consultations by appointment. You can go onto our website. You can schedule with me. You can schedule with one of our other healthcare immigration lawyers, Adam Cohen or Megan Moody, who are also wonderful and available. So we are always happy to do consultations. You can connect with me, my LinkedIn. If you search for me, I come up there. I'm also on Blue Sky and Threads, and I share information in all three of those places as it comes up. So I am going to stop sharing so I can get to the Q&A, because for some reason it wasn't there. It didn't pop up. Let's see. So there's lots of questions. So let's see. We will start off with the first one. So the first question relates to the $100,000 fee and asks if, somebody's in H-1B status and they have a job with one employer and they're looking for a new employer, will the fee apply? And the answer is probably not. If you change employers entirely within the US and you don't leave during the course of that H-1B process, then the fee should not apply to a change of employer while still in H-1B status. And if you're in H-1B status now and you have a valid visa stamp, yes, you can travel using that. The fee will not be implicated. One thing I've been telling my clients is I don't know necessarily what changes are coming. But I also don't like to tell people not to travel, right? Like, it's a hard thing to say. So right now, the way I put it is there is no legal prohibition on travel. If you are already in H-1B status, have an H-1B visa stamp, there's nothing I can tell you in the law or in policy that says don't travel. There is an inherent risk in traveling, though, because we just don't know what policies might be coming. So keep that in mind. But by all means, if you have a valid visa, you can travel. And the fee will not be implicated for you. And then we have another question here. So yeah, we covered this in the early part of the presentation. So the fee does not apply to changes from J1 to H1B status that are done all entirely in the United States. So if you are here in the US, the fee should not apply if you change status, have an extension, have an amendment, whatever it is, and it all happens here. What triggers the fee is processing from abroad. And that really is the key factor there. I think one thing I can kind of mention that may help also is, sometimes I have clients that don't look for their J1 waiver job on the early side, right? Like I always tell folks, if you're in J status, it's never too early to look for a job. Get on that on the early side, because the J1 waiver process takes time. So one challenge is that every year we have folks that we're filing waivers for in the summer because for one reason or another, they didn't sign a contract until after they finished their residency or after they finished their fellowship. And that raises the risk that that physician is going to have to leave the country before their H-1B is filed because we run out of J time and the waiver is still pending and we can't file anything for them to change their status in the United States without the waiver. That's what the waiver does. It allows you to change status in the United States. So one of the challenges now is in those cases, the $100,000 fee is going to be implicated if the physician has to leave the country in between the J and the H. We don't want that to happen. So, for those of you in your final year of training, I can't emphasize enough how important it is to, really get on that job search and try to, it's a hard balance, right? I don't want to sit here and tell you, well, you got to sign a contract soon, right? Because I want you to find the job that's best for you. I want you to think about things other than immigration when you're going through your job search, because that's really important to find a fulfilling match in your, first job following training. At the same time, like this is not the year to wait until June to sign a contract, right? Like we really, it's going to be in your best interest to try to, sign a contract sometime between now and February is March at maybe the latest, depending on the program and all of the ramifications of that. But, certainly, this is a year to really be on things on the early side. Okay. Can a spouse of an O1 work in the US on a spouse status? And the answer to that is no. The O1 spouses actually come in O3 status. You would think that like all the spouses would get the same number. Like you've got J2, H4, O3, P4, like all these different numbers. You would think all the spouses would just get the same number, but they don't. So O1 spouses and children come in O3 status. And unfortunately, unlike the H4s or the J2s, O3 spouses cannot obtain work authorization in that status. There's no EAD they can apply for. Now, if a person is qualified for another status, like an H or a TN or something else, then they may be able to get their own work authorized status that's not connected to you as the spouse. But in O3 status, unfortunately, there's not the ability to work. They can go to school. O3 spouses can take classes, they can be in degree programs, but can't work. Let's see. So great question. What happens if the H-1B fee, the $100,000 fee might apply? Can you do an O as an alternative? And the answer is yes. The only immigration status that is affected by the $100,000 fee is the H-1B. So if you're eligible for O status, then yes, that can be a good alternative to bypass the H-1B fee. And we actually have been consulting on that quite a bit recently, really considering whether physicians are eligible for O's. One word of caution, and actually, I'm glad you brought up this question. So one word of caution is that right now we are seeing an uptick in RFEs on O1 cases, and I suspect that as more and more folks are going to look to the O as an alternative to the H, we may see an uptick in pushback from the Immigration Service as officers will be more and more skeptical about whether someone actually qualifies for the O or whether they're just filing it as an end around the fee. So that's just something to be cautious about. The other thing I would recommend being cautious about is trying to use visitor status to get around the H-1B fee. The presidential proclamation specifically says that the administration is going to be on the lookout for abuse of B1, B2 status as a way to avoid the fee. So I've had people ask me just recently, well, what if I come back to the States as a visitor? Can you just change my status to H-1B? And the answer is, well, legally, yeah. But there's a huge risk there because if the government decides that you misrepresented yourself on your way into the US on that B1, B2, not only that might they deny that H1B because they're going to decide it was subject to the fee, but they also may cancel your B1, B2, or if you can't, and maybe impact your ability to ever come back to the US as a tourist again or be eligible for a future visa. So it's really, really important to take seriously when they say they're going to look into that potential abuse of the B1, B2, to not be tempted to do that. And I think that O's, it's not going to be a fraud thing with the O's, but I do think we're going to, there's going to be an uptick in the number of O's that are filed, and then we're going to see an uptick in the percentage of cases that are RFE'd. So we're trying to be pretty realistic in our office about assessing O1 candidates so that, we can make a good decision on those. Okay, so next question. Let's see. Oh yeah. Oh, that's a tough one. So this person says that they are on a J, they got a hardship waiver, but their country is also on the travel ban list. So they can't leave the United States to change status, or they won't be able to come back. I mean, I think the challenge there, and that's a really hard question. I think that's actually a question that would require a longer consultation than I can do in this setting. But I think the challenge is that filing for an H-1B from inside the United States legally is not available. Still might be something to, you have to think about whether it's ethical and okay to file for it and ask for the change of status, basically asking USCIS to grant it in their discretion because of the travel ban. knowing this administration, they may not necessarily care about that. But yeah, I'm sorry to hear that you're in that situation. That is a really tough situation. I guess the other thing to think about, and typically with J1 waivers, it's a one waiver to a customer kind of a thing. So once you get the hardship waiver, you're usually stuck with that. However, I am aware of a handful of cases where somebody got like a Conrad 30 waiver, an underserved area waiver, and there was a problem and they couldn't finish out their waiver service and they were able to then apply and get a hardship waiver approved. So it was kind of backwards from what your situation is. But I wonder if there may be an opportunity to apply for an underserved area waiver, explaining to explaining to the State Department in the context of that you're unable to, maintain status in the U.S. through the hardship waiver process. I don't know if that would be successful because the State Department usually will not grant a second waiver, but in key cases, they seem to have some willingness to do that, and that may be an option. So the next person asks whether, if there's any hope for the H-1B lawsuit or national interest exemption. So there are two lawsuits now pending. The first lawsuit that was filed, our law firm actually was part of that effort to file. It was our firm that was onboarding plaintiffs for the litigation. And that case was filed in the Northern District of California, I think on October 3rd. I do not have any information about the status of that lawsuit, and that's sort of on purpose. And the folks that are working on the lawsuit are not at liberty to talk about it. And so there's sort of like a firewall in our office. And so I don't have any information I can share publicly with you about the status of that lawsuit. And then just last week, the U.S. Chamber of Commerce filed a lawsuit in the district for the District of Columbia in Washington, also challenging the fee. And the complaints for both cases are available publicly online. The chamber complaint is really excellent and tells a really great story. So if you have a chance and you're interested, you certainly could find those online and read them. I do think both lawsuits, I think the litigation is very meritorious, and I'm not just saying that. There are lots of reasons why this fee is illegal, and that the president doesn't have the unilateral authority to issue a tax. He doesn't have the authority to set fees for immigration applications. They haven't explained what this payment is going to be used for. Like, what is the $100,000 even for? Why that amount, right? Like, they haven't tied that to anything in particular. So there are lots of problems with the proclamation and the way that this was done. So I do feel pretty confident that a judge is going to see things our way eventually. I can't give you any information about the time frame, to expect or anything like that. And of course, we'll see what happens down the road. But I do have hope for the litigation. I think that the national interest exemptions for physicians before USCIS issued its new statement earlier this week, I was thinking that exemptions for doctors were going to be like a no-brainer, right? Like, it just seems like it should happen. The language of the exemption that is on the USCIS website is really, really not good. And in talking with colleagues this week, it does feel like they have created a very high hurdle to clear to get an exemption. Now, that doesn't mean it's not going to be possible. I have a few nurses and some doctors that were thinking about filing for these exemptions, and we're starting to, send out, figure out what our document checklists are going to look like and what all the information that we need is. But this is only a couple of days old, and it's hard, nobody's applied for one yet, as far as I know, and nobody has gotten a decision, as far as I know. So until we start seeing people apply, and we get some sense for what USCIS is going to do with them, it's hard to give you a sense of how successful these things might be. But I'm hopeful that maybe when it comes to physicians, they'll be like a little more lenient on granting the waivers or the exemptions, because it just seems really silly to not, right? Like, if anybody qualifies for one of these waivers, it should be nurses and doctors and other folks that work with patients. I just don't know what else you could say about how important our international healthcare providers are to the U.S. healthcare economy, to all of us, right? Like, I think Myself included, and many members of my family have seen physicians who came to the U.S. from other places. So, it would seem to me to be kind of ridiculous to not grant the exemption, but until we start to see these being adjudicated and get some feedback on them, uh, it'll be hard to specifically say, what's likely to be successful and what's not. Um, and I think did I hit the end of the questions? I think I did. Ooh, yay. So I think we just hit the top of the hour and I got to the last question. I think that was perfect timing. Thank you all so much for being here. And oh, I saw there was one other one that came in. There are a few, actually, I just refreshed. There were some more questions, but I think we're going to have to leave it at that as we hit the top of the hour. I do see the one question about premium processing, and no, there haven't been any changes to that. So thankfully, no changes to premium processing right now.
Perfect. Well, thank you so much, Elisa. I just want to remind everyone that this webinar was recorded. So I'll be able to send you all the recording link by the end of the week. Elisa did share her information to contact her or her team at the end of that webinar. So you'll be able to see that in our recording. Thank you all for attending. Thank you so much, Elisa.
Thank you. Have a great night.
Thanks, everyone. Have a good night.